Dear students, um, we will continue in this lecture the matter of the dual nationality or the multiple nationality. And we have said that the multiple nationality means the case when the person has more than one nationality. And I told you what is the problem regarding this dual nationality, what are the problems caused by dual nationality regarding the performing of the military service, practicing of the political rights and the conflict of laws, and how the loyalty cannot be distributed between two or more states. So the person, it's logical that he has loyalty for one state. This is the logical thing. I told you that because of this problem, I mean the dual nationality, there were many regional and international conferences in order to put an end for this problem. We discussed the images of the dual nationality or the reasons why the dual nationality as disease in the field of private international law exists. It may be that the dual nationality happens contemporaneously to the birth. I mean, when the person is born, he has double nationality because of the double bases. I mean, use sanguinis and use solely principles, or it may happen after the birth, posterior to birth, and this happens because of the naturalization, or like when the person accepts or acquires another nationality by marriage, or even by residency for a certain period of time. The person himself may become a person with two nationalities, and according to the family dependency, it's made that his children and women can also acquire the same nationality that the person, I mean the husband, acquires, and in this case they will all suffer from the problems of the dual nationality. And it's made that we face the case of dual nationality in if the married woman keeps her nationality according to her law, and the same time acquires the nationality of the husband. So in this case, the woman will be with two different nationalities. Well, in this lecture, inshallah, we will talk about the how to be or how to put an end to the problem of the dual nationality. Against this dual nationality, despite all the efforts exerted in the field of private international law conferences to put an end to the disease of the dual nationality, this dual nationality still exists, and we still face the problematic that is caused by this dual nationality. And there are ways that state may follow in order to fight against the problem of the dual nationality. I mean, as feminine or as disease, as we described previously. So, what are the ways or the mechanisms that can be followed by states in order to put an end for the dual nationality? Well, number one, the states can put an end for this problem by unifying the legal basis of granting the nationality. Like, for example, states shall choose either or. What either or? Either the use solely principle, like every state gives its nationality to the person who is born on its territory. Every state around the world shall accept this idea, or they must grant their nationality for persons who are born for national fathers or mothers, or both of them, on the basis of the jus sanguinis principle. So, what I mean here is that states, every state around the world, shall choose between these two principles. However, this choice must be made typically by all states. Like if you visit any state, you will find the law of nationality in it. It adopts the same principle. Whether use soli, I mean, all states shall accept this principle, or even use sanguinis. لكن بنقول إنه practically this is hard to be accepted by states لأنه البوليسي المتعلقة من دولة لدولة من ناحية تعداد السكان it differs. For example, in China, they cannot allow, for example, the use sanguinis because they do not want to increase the number of the population. هم مش طايقين اللي عندهم أصلا عشان يروح ياخد لي بمبدأ سهل إنه نتيجة وجود تجار وغير وغيراته. الموجودين عمليا بالصين حياخدوها وفق اليوس سولي، فيش مشكلة، لكن كمان تجيب لي أجانب ياخدوا الجنسية عندي إذا انولدوا عندي على الإقليم، فصعب إنه الصين تاخد بمبدأ اليوس سولي. Same for states which has a very large number of population like India. However, some states like the European states, I mean in East Europe, they tend to increase the number of the population. That's why they adopt the principle of the use solely, not use sanguinis. فكيف انت تيجي تقول له والله لا تعال بدنا نفرض عليك زي ما احنا فرضنا على كل العالم يوز سانجوينس، انت بدك تصير يوز سانجوينس؟ هم اصلا ما عندهمش سكان عشان يعطوا الجنسيه للي بده يخلفوهم، او هم بيعانوا من الشيخوخه، فكيف بده يجيبوا اولاد وياخذوا الجنسيه على اساس انتقالها بالدم وتمنع لي حق الاقليم، وبالتالي ما فيش شباب ياتي الى هذه الدوله. فعشان هيك بنقول المشكله عندهم انه سياسه الدول the policy of the states it differ from a state to a state because some states tend to increase the number of the population. However, another states they tend to decrease the number of the population because they suffer from the large number of population. That's why في مثال كنت بدي أنا أضرب لكم إياه في بداية المحاضرة على مسألة إنه كيف لما الستيت بيكون عندهم different principles, like some states they have use sanguinis and the others have use soli, and how this differentiation between or the difference between states regarding the principle that they adopt, it affects on the problem of the dual nationality and it affects on the other aspects of life. There is a very famous example in the field of the nationality and the dual nationality and its problems. It's called the Carlet case. The case of Carlet, he is a person, he was born in 1816 Belgium of French parents. Okay, so he was born in Belgium and on the Belgium territories. However, his father and mother are French. So he obtained the French citizenship or the nationality because his father and mother are French. So he acquired the French nationality on basis of the jus sanguinis since his birth. Okay, so since his birth, he acquired this nationality according to the jus sanguinis. Also, he obtained the nationality of Belgium because Belgium adopts the principle of jus soli. So everyone who is born on the Belgium territories, he shall have the Belgium nationality. So the jus soli principle or basis in relation to the child of a foreign father if he requests. So if he requests that within 1 year of reaching the age of majority. So according to the Belgium law, the Belgium national is the person who is born for Belgium nationals or parents, and also it adopts the jus soli principle. So everyone is born on the Belgium territories can have the nationality. I mean the Belgium nationality, if he requests for this nationality when he reaches the age of the majority. I mean 18 years old. Okay, so this person, I mean Carle, he has double nationality, the French nationality according to the space, and the Belgian nationality according to the spaces. So in 1998, Here's the problem of the dual nationality that he enjoys. The conflict raised between France and Belgium when the aforementioned performed a military service in Belgium, and he demanded his exemption from this service in France. Like this person, he is French and he is Belgium at the same time. So he considers himself to be a Belgian person, and he committed or he served, or he earned his service, I mean the military service in Belgium, and he was demanded to do so or to do the same in France because he is a French subject. So he demanded for exemption from this military service in France. And this dispute did not end until an agreement was concluded between France and Belgium. يعني في مشكلة إنه أنا اليوم فرنسي وأديت الخدمة العسكرية فرنسي وبنفس الوقت بلجيكي. في بلجيكا أديت الخدمة العسكرية، فليش أنا أديها كمان في فرنسا؟ ما خلص. فعشان هيك هو طلب من الفرنسيين إنه يعفوه من الخدمة العسكرية، فهم الفرنسيين قالوا له لا، أنت رعية فرنسية فلازم تقوم فيها، حتى لو أنت قمت فيها ببلدك الثاني اللي هو بلجيكا لأنك حاصل على جنسيتها، ما بيعنينا. أنا بيعنيني إنه أنت رعية فرنسية، فكيف أنا أعفيك؟ أنا ما بطلع على الجنسية تبعت الدول الثانية، بطلع على جنسيتك ورابطتك معي. فهذه المشكلة سببت أزمة between France and Belgium because it doesn't apply only to Carlet case, because there were many cases alike to Carlet case. So how the problem ended between these two countries? Well, in 1998, uh, the problem was solved through an agreement stipulated that each shall he shall be exempt from military service in France, whoever is born in Belgium to a French father and chooses the Belgian nationality. So anyone who ever is born in Belgium, but he chooses the Belgian nationality instead of the French one. I mean, it is the effective one, not the French one. Or the opposite. Whoever is born in France to a Belgian father, however, he chooses the French one, which is effective, he shall be exempted from the military service in the other state. يعني كانوا بيقول لي أي واحد انولد في بلجيكا لأبو فرنسي وحاصل على الجنسيتين، الجنسية الفرنسية على أساس الدم من أبوه، والجنسية البلجيكية لأنه هو طلبها لأنه موجود في بلجيكا وأدى الخدمة العسكرية في بلجيكا، بيعفى منها في فرنسا. والحالة العكسية نفس الشيء، واحد فرنسي أو عفوا واحد بلجيكي وجد في فرنسا لأبوين بلجيكيين أو لأبو بلجيكي واختار الجنسية الفرنسية وأدى الخدمة العسكرية في فرنسا، ممنوع بلجيكا تيجي تطالبه بالخدمة العسكرية. يعني هو عمليا الأجريمنت هنا حطت حل لمشكلة مترتبة على مشكلة الدول ناشوناليتي، لكن ما حلتليش الدول ناشوناليتي as problem. So the agreement made by both France and Belgium, it ended the problematic regarding the military service that the person shall do when he has double nationality. However, this agreement, it doesn't put an end for the problematic of the dual nationality itself. So this is the problem. This is why we say that it is hard to unify the legal basis of granting the nationality. Since we cannot do this, the problem of the dual nationality will continue. Now, you can put or you can minimize the problematics made by this dual nationality. However, the dual nationality itself, you cannot minimize the problem or even end it. Another way is giving the chance to the individual to choose between the nationalities that are granted to him or her. And this actually requires the existence of an agreement between states according to which the individual have to choose between the nationalities that they enjoy. يعني انت اليوم صار عندك دول nationality، بتيجي بتقول له الدولة اللي هو فيها تعال يا باشا، you have two nationalities, Belgian nationality and French nationality, like what happened in the case of the Carlet. Come here, Carly, and decide which nationality do you want to enjoy. Do you want the nationality, the first one, I mean the by birth, which is the French one, or after birth, which is the Belgian one? If you choose the Belgian one, you have to drop your first nationality because we do not want to have any kind of problems with the other states. Like we have a problem with France regarding the military service, but we do not want to have any other kind of problems in the coming future. So please drop your French nationality, or we will not grant you the Belgian nationality and keep your French one. So the person here shall choose between the nationalities that he enjoys or she enjoys. Okay, so this is one of the problems, but this, or one of the ways. However, this way is hard to be conducted because some states cannot detect that this person has double nationality. For example, no one can detect whether, for example, my mom, she has, I mean the Lebanese authorities, they cannot know, or they cannot be sure whether my mom acquired officially the Palestinian nationality or not. What can make them sure of this? And this applies to every case. Like, I am Palestinian and I acquired the Belgian nationality because I immigrated to Belgium, for example. Now the question here, do the Belgian nationalities know that I still keep the Palestinian nationality or I drop it? They do not know actually. So how can enforce me to choose between two nationalities? However, they do not know that I have already two nationalities. So this is why this problem is not, or this way is not imaginable to be applied by all states, because states themselves, they cannot be sure. For example, I have a relative, he has three nationalities at the same time. He is Palestinian because his mother was my cousin and she is Palestinian. So he acquired the Palestinian nationality according to the principle of sanguinis principle, or the jus sanguinis. His father is Lebanese, I mean, the husband of my cousin, he's Lebanese, so he acquired the Lebanese nationality and passport because he is born for a Lebanese father, according to the jus sanguinis principle. Both the father and mother, I mean the husband and the wife, they were in Canada when their son was born. So he acquired also the Canadian passport and the Canadian nationality on basis of the jus soli principle. So he has three nationalities the same time: Canadian, Lebanese, and the Palestinian one. He has three passports. No one of these states know, I mean the authorities in each state, then they do not know whether this person already has the other nationalities or not. That's why this way, I mean the way number two, is difficult to be applied. Number three, it is one of the solutions. It says you will not be granted the new casual nationality. انه احنا مش هنمنحك الجنسيه الجديده العارضه اللي هي by naturalization until you drop your natural one. هذه ممكنة التنفيذ. يعني انا باجي بقول له انت كبلجيك، انت شخص فلسطيني جاي بدك تطالب بالجنسيه البلجيكيه على اساس الناتشراليزيشن، وانت اجيت مش لاجئ اللي انا ما اعرفش انه الضايله عندك الجنسيه او لا، وانت اخفيتها اصلا. انت عندك جنسيه فلسطينيه، جاي كطالب عندنا ببلجيكا، وجيت اتجوزت بلجيكيه واقمت فتره، وعلى هذا الاساس بدك تاخذ على اساس الناتشراليزيشن باي مارriage اور باي ريسيدنسي you want to acquire the Belgian nationality. هنا بتيجي السلطات البلجيكيه لانه عارفه عمليا انه انت مواطن فلسطيني واجيت بشكل رسمي على البلد وعندك Palestinian nationality. They may say to you that you will not be granted the Belgian nationality until you drop your natural nationality, which is the Palestinian one. Okay, so states may stipulate that the individual shall not enjoy their nationality by naturalization unless this person relinquishes his previous or her previous nationality. So in this case, we can put an end to the problem of the sorry, the problem of the dual nationality. Uh, well, this is a solution. However, it may lead to another problem, which is the problem of the statelessness. Let me give you an example here. X, as person, he believes family. I mean, she's female, afwan. She's female, he believes. I mean, a state, okay? She married to Y, who is Hagalese male. So he's the husband. X loses her Hibali's nationality because of because she wants to acquire her husband's nationality. I mean the Hagalese one. Why divorced X, who loses her husband's nationality accordingly. واي طلق اكس. اكس خسرت الناشوناليتي اللي اكتسبتها من واي على اساس المارج. الان السؤال، هي خسرت جنسية جوزها وبنفس الوقت هي خسرت جنسيتها اللي هي باليز because she accepted that she wants to drop her nationality in opposite of acquiring the new nationality. So the problem here is that she loses both nationalities, her original nationality or the natural nationality, and she also loses the nationality which was acquired through marriage, which is the Hagalese one. So this matter, I mean, this solution, it may lead, I mean, the solution number three, it may lead sometimes to the problematic of the statelessness. بتخلي الشخص عديم الجنسية إلا إذا كان يعني في بعض الدول بتقول للمرأة إنه إحنا بدنا نسقط عنك الجنسية واكتسبي جنسية جوزك مع حقك في استعادة الجنسية في حالة طلاقك. هذه بعض الدول اتنبهت إلها إنه أنت صحيح اتطلقتي من جوزك وخسرتي جنسيته وخسرتي جنسيتنا اللي من أول، بس إذا رجعتي يمكنك أن تقدمي طلب لاستعادة الجنسية الأصلية تبعتك، وبتستعيدها كحل من الحلول اللي بتواجه مسألة الستيتلسنس على الوجه اللي حنشوفه إن شاء الله لما نوصل موضوع للستيتلسنس. آخر شيء إنه مسألة الدول ناشوناليتي بفور ذا ناشونال جادج. إيش اللي بيصير عمليا لو واحد عنده عدة جنسيات وقاعد بيتقاضى أمام قاضي وطني. خلينا نقول let's imagine that the person he is Egyptian and French at the same time. He has double nationalities, the French nationality and the Egyptian nationality, and he is prosecuted or even litigated before the Egyptian courts. Which one or which law shall be applied in this case? Well, according to Article 3 of 1930 Hague Conventions and Article 25 of the Egyptian Civil Code, the Egyptian law shall be applied in these cases. Shall be applied in these cases as a general rule. As a general rule. In some or to some extent, the French law can be applied in certain matters. However, I don't want you to know anything about them in this moment because I will discuss them in the other course, which is the conflict of jurisdiction. So, and the conflict of laws. So all you have to know is that the Egyptian law shall be applied as general rule. Okay. Shall you have further inquiries? Please leave any question, any query in a comment on my YouTube channel, or even send me these questions and inquiries to my email. Thank you very much for your patience and goodbye.